and now it's time to solve your legal problems. And to do that, we have with us Mr. Uday Vavikar. He's a senior advocate. Welcome to the show, Uday. Okay, let's take our first query. Kushmanda has sent his question over email. He has said that he has invested in a project called Vaswani Menlo Park in 2015. And till now, they have not started the work at all. In fact, they've also changed the name. And every time he calls and asks about the construction stage, he's told that it's still in pre-launch phase and the work will start in next couple of months. But again, when he called up after 2 months, the same thing was told to him again. Now it's 2017, and now they are saying that due to RERA, the work is not in progress and it might resume in April sometime this month only. He wants to know, he's already invested about 12 lakhs in that project. What options does he have, Uday, here?
The point is that, first of all, RERA is only a lame excuse, and there is nothing about RERA to say that the projects are delayed from 2015. There was no RERA at all. So this is something absolutely absurd. The option that he has got is he can walk out of these investment by filing a complaint before the consumer court saying that I had booked, the flat is not getting ready. Either they should give me the possession in stipulated time or give me the proportionate market value of what I have paid of the total consideration, or alternatively give me a flat in the same nearing locality, alternate flat of the same size, of the same value and of the same type. That also can be asked, and consumer courts are progressively giving this kind of judgment. He has to first register his builder-buyer agreement, because that will make him more safe. One of the prayer will be, first prayer will be, give me the agreement, or then finally it will be, in case of if he wants the possession, he can continue in consumer court or ask the refund, as I said, with the interest, that to 22 to 24%, 18%, or the market value, as I have said, or alternate flat. These are the things. I think consumer forum would be the best. He can also go to civil court and file a cheating case in the criminal court.
Okay, so
he can file a FIR.
Okay, so very importantly, Kushmanda here, please don't let any builder, or for that matter to all our viewers, please don't let anyone tell you that RERA is the reason for any sort of a delay. Don't let them throw this phrase at you. It's absolutely not true. Anyways, let's go ahead and take our next caller on here. We have Deepak with us right now. Deepak, what's your problem? What are the legal issues you are facing?
Yeah, actually, I had booked a flat in November 2014 under PMI scheme from builder Ajnara Lee Garden. So now, since February, the builder has stopped paying the pre-EMI, and they are saying, they have just sent an email to all the buyers, and they are saying that it is intimation of offer of possession. On the basis of that, they have stopped paying the pre-EMI. And also, they are charging Pratikar charges, extra Pratikar charges at ₹70 per square feet. And also they are now demanding advance maintenance for 2 years. And club charges also they are asking. And the club is not at all ready. So what, as a buyer, what we can do?
Absolutely. Uday, it seems a lot of charges, fees is being taken over here, but nothing is being given back to the buyer here.
So the first question here is whether he has got an agreement registered or not. Because if the agreement is registered, the terms must be there in the agreement, and builder can't unilaterally, arbitrarily, and as per his whims and fancy change the rates, or ask the additional charges, and that would be incorrect. It will be unfair trade practice as far as the builder is concerned. He can go for civil damages, he can file a consumer court case for unfair trade practices and deficiency of service, and that will be excellent for him for illegal and unjustified amount and unjust enrichment. That would be, the consumer court would be the best recourse for him, because it is much faster than civil court. He can also file a cheating case and file an FIR in police, because if he files that, there will be also pressure, but he has to follow up. I think consumer case looks to be the best option for him, and he can claim the possession and other relief from the consumer courts, and they are pretty faster comparatively. In Noida, there is a forum for them. If the flat is below 20 lakh, if the flat is above 20 lakh, there is a state commission in Delhi, or above 1 crore, he can go to before the national commission, which is also in Delhi. So the thing is, he can get even an interim relief if he wants to see that the flat is not sold by the builder to the third party and reserve his flat, or any other interim relief provision is also available for him. So there is a lot of ray of hope for him, but he should be able to fight and be patient.
Absolutely. Let's take our next question. We have an email from Vipin. He says he bought a plot in Bangalore with Samskruti Builders, and he paid the entire amount at that time, and the sale agreement mentioned that the plot would be ready in 6 months. Now it's been 10 years now, and there's no sign of the project or community that he had bought the plot in, and he's been trying to contact the builders for last 4 to 5 years now, and he's been asking for his money back, but the builder doesn't seem to have any intention of doing so. So what are the options for him? Because 10 years is a long time.
It's a very, very long time. In fact, he should have acted within 2 years, and that is the limitation under MOFA. But there is a good news for him. Supreme Court recently has given a judgment, and they have continued with such judgments, saying that in case possession of the flat is not given for you, even after 20 years, you can definitely ask a possession, and your cause of action is continuous, which is a good ray of hope and silver line to our complainant here. But at the same time, he has to send a legal notice first to them, that as to what is the reason there is a delay. If the legal notice, there is an answer which is not satisfactory, they can, as it is rightly, he can file a consumer complaint, demand back his money with the interest, claim current market value, because 10 years back, what was the cost of the project, he can't buy a house. So proportionately, he can get even current market value, and there are progressive judgments on this. And also ask for legal cost and mental harassment costs in case he has taken a flat on the rent. Even a rent can be asked, provided there is a rent agreement and proof of the rent receipts. He can even ask a rent as an interim relief till the flat is completed. So there are various options under consumer. He can also file suit for civil damages, which may take time. And of course, he can also go right to various authorities, especially the government authorities, for the purpose of settling of his grievances. But what is most important is, and most effective tool for him would be consumer court, or he can go simultaneously, he can go with a criminal cheating complaint against the builder, and progressively police is also taking action.
Vipin, this is a huge relief for you that the limitation does not stand. You can take legal action, and please don't hesitate to do so. Please go ahead and do it at the earliest. Anyway, Uday, thank you so much for joining us and answering all these questions.